New at 9, they're your records. You paid for them. But a new state Supreme Court ruling may make it even harder for you to get access to anything that law enforcement says is part of one of their investigations.
And as our On Your Side investigator Jonathan Hardison explains, the state's Chief Justice warns this ruling could be the end of what little public access we have now.
Dead last. That's where Alabama ranks in a national study of how states follow their own open records laws. And Alabama isn't just 50th, it's 51st when you include the District of Columbia. That means if you're looking to find out who's spending your tax dollars and how, you're in the worst place in the country. And that was before a new state Supreme Court ruling that could tie your hands even further, asking for information supposed to be public.
We might as well call it closed records law, because this could be construed, can be interpreted very broadly, and that's very dangerous.
The new ruling involves a 2017 case out of Mobile, where a Baldwin County deputy shot and killed a driver who deputies say kept approaching them in a shooting stance, even after multiple commands to stand down. A weekly paper from South Alabama asked the department for body and dash cam video, as well as 911 calls and pictures from the scene. But the sheriff's office denied that request, claiming an exemption to the open records law that covers investigative records, even long after prosecutors had decided not to charge the deputy involved with the crime.
And if there's something like body cam video that actually shows something happening, that's not in question. Those things are not necessarily confidential in an investigation because they happened along with the event, and the event is fact.
That's the Alabama Broadcasters Association position, but the state's highest court ruled almost unanimously the exemption keeps those records out of your hands. A ruling so broad, the only dissenter, Chief Justice Tom Parker, wrote, quote, "With one sweeping stroke, today's decision spells the end of public access to law enforcement records that are connected in any way to an investigation."
I mean, having the Chief Justice say this needs to be done should get some attention. You'd like to think so.
The ABA has worked for the last several years to update the state's open records law and more clearly define what you can and can't have access to, and lay out clear timelines to get a response, an effort that has died in committee each of the last couple of sessions.
Maybe you had a traffic violation and there was dash cam video, and you want to request that in order to go to court and argue whatever tickets you got or whatever charges were brought against you. You should be able to have the access to that, as well as the law enforcement agency that had the dash cam in the first place. Don't think that in general people realize that could be me. That could be me or a family member that needs access to whatever this record is. And it should be unthinkable to you that you wouldn't be able to get it.
Jonathan Hardison, WBRC, Fox 6 News, on your side.